we are moving from one country to the other country, as if we are moving from one district to the other district. Earlier, we used to protect and enforce the international or the protection of trans-border reputation. That is, because if the property or the goods are not in the country, but their goodwill and reputation is circulated or is prevalent in the country, then we try to protect that property in the country, although that is not available physically in the country where protection is being sought for. We used to speak of this trans-border reputation. In India, we also had number of cases where we had given protection on the basis of trans-border reputation, although physically the goods was not available. Delhi High Court, there were a number of cases on that. There were cases of the Supreme Court of India on that. But now, with the changes, that is the globalization that has set in, there is no question of any trans-border reputation. People are moving from one country to the other, as I said, at their free will. Goods are moving from one country to the other country. There is anti-dumping law coming in. People are dumping their goods in the other country. And therefore, this subject has assumed a lot of significance and importance in the modern times, and we are here to discuss about the pros and cons of the problem that all these state players in this branch are facing. Now, so far India is concerned, we have, because as you probably by now all know, that we have a TRIPS agreement, and the signatory member countries are required to make their laws, intellectual property right laws, in compliance of the TRIPS requirement. Now TRIPS, we became a signatory of the TRIPS agreement in the year 1995. India became a signatory of the TRIPS agreement in 1995. And 10 years time was given, thereby meaning that by 2005, we were required to make our laws, all intellectual property right laws, compliant to the international standards, the standard laid down by the TRIPS. And so therefore, India amended the Trademarks Act in 1999. We updated and made it compliant to the requirement of under the TRIPS agreement. We also amended the patent law in 2002 and 2005. Different amendments were brought in. Copyright Act was also amended. Major amendments were introduced in the year 1994, but major amendments were brought in 1999. So far Trademarks Act is concerned, as I said, 1999 we amended. But that did not satisfy what was required to be done, and therefore we are trying to bring in an amendment bill of 2007, which is now pending before the Parliament. Now, therefore, by bringing in these amendments or substituting the old Act by a new Act in terms of the requirement that has been laid down, we have tried to protect the intellectual property rights. Laws are made, but unless those laws which have been made for the protection of the IPR, is there no seat available here? Can we close that door, please? Unless we make all these laws enforced properly and appropriately, we are not going to achieve the purpose for which these laws have been made. Therefore, we have been trying to enforce. Not that we are trying to enforce these rights only recently. We have been trying to enforce these laws even prior to the TRIPS agreement that we had signed. but for some reason or the other, we are unable to dispose of the matters within a specified time period. There have been pendency of the cases in the IPR sector also is concerned, but we have tried to update the law. We are trying to also update the disposal of cases by adopting different modes, and we are going to discuss a few of them as to what we have been doing in the courts, because as you know, we have to enforce these rights in the courts, and so what steps we are taking, and those steps that we have been taking are the new challenges so far intellectual property rights are concerned, which is the subject which is being discussed here. We have a panelist, a long panelist. Justice P.S. Narayan is with me. He is the judge of the Andhra Pradesh High Court. Mr. Donald Johnson is on my right. Mr. Robin Jacob is supposed to arrive, and Mr. Parag Tripathi is also would be here. So therefore, we will be discussing all these that steps we have taken for enforcement, for protection and enforcement of these rights and the new challenges that we have. Now, so far enforcement is concerned, before I hand over my mic to my friend here, I would like to give you a little bit background as to what steps we have been taking so that there could be an effective discussion on that. Now, all these rights, that is intellectual property rights, are to be enforced by the provisions made in the Specific Relief Act. All of us, we know about the Specific Relief Act. We have to file a suit for protection of our intellectual property rights, suits as envisaged under the Specific Relief Act. Now, Specific Relief Act envisages filing of injunction suits. Injunction could be of two types, that is the permanent injunction and the temporary injunction. So therefore, when we file a suit for protecting our intellectual property rights, we file a suit for injunction claiming a decree of permanent injunction with regard to the particular infringement that is being alleged, and there we pray for a grant of temporary injunction. Now, there are three factors which are considered for granting an injunction, particularly the temporary injunction, whether there is a prima facie case or not, whether there is balance of convenience, and whether there is irreparable loss or injury. These are the three factors. You all know about it. This is very basic. But let me tell you, this is not the end. A new concept is being developed. And what is that concept? That while granting injunction, the public interest is also to be taken notice of. Now, this concept has been imported from, like we import goods from other countries, from the United States Supreme Court. There is a case, eBay's case, which decided a infringement matter only, an infringement of a copyright matter, where the concept of public interest was also imported for granting an injunction. If the order of injunction is going to affect the public at large, no injunction should be granted. We have adopted that in India, first by the Madras High Court and then by the Delhi High Court. In Novartis case, I'll give you the examples also how we have done that. In Novartis case, which was a case of drugs, pharmaceutical drugs, it was a drug for cancer, treatment of cancer, a terminal disease. Now, the Indian market used to sell the same pharmaceutical products or the drugs, that drug at a cheaper price than what is available in the international market. But the patent was held by an international market, an international company, who used to sell it at a very high price. But that is, Novartis used to sell it in the international market, the same drug, at a very high price, whereas in India, the same drug was being sold at a lesser price. Now, Novartis filed a suit for enforcement of their patent rights, and in that they sought for an injunction against the Indian company who was selling it at a lesser price. See, the patent was being held by that multinational company, but still the court did not grant the injunction in their favor, although they had all the other three factors in their favor, on the ground that they did not have the public interest on their side. Public interest because it is a drug for treatment of a terminal disease. The injunction was not granted. The same, of course, was not challenged in the Supreme Court, and therefore I am free to say about that. That has become final and binding. That concept of public interest is also now embedded in the concept of the three, in addition to the three factors that we have. Now, there is also, we are granting an injunction of this nature, taking public interest into consideration. In a case in Delhi also, the case of Hoffman La Roche versus Cipla. Cipla is a multinational company. As against that, injunction was not granted. Now, we have also in the courts, we are granting John Doe orders. Now, what is this John Doe orders? This is injunction order, nothing else. We have number of different types of injunction orders. John Doe orders, Maleva injunctions, then Anton Pillar orders. These are injunction orders. Now, what is these John Doe orders? Now, we have been granting this sort of orders even by this Delhi High Court. Now, these copyright violations. Now, movies, as soon as they are released in the theaters, the cable operators on the very next day put it in the cable network. This is piracy, nothing else but the piracy, infringement of the copyright. And case was filed by the distributor of that movie in the court, saying that I am going to, my copyright is being infringed tomorrow by the unknown cable operators. So give me an injunction so that they cannot telecast my movie into the cable network. Court was at a loss, but ultimately, by taking help of these John Doe orders, which are being issued by different courts in different parts of the world, injunction orders were issued as against unknown infringers or the violators, without naming them, that whosoever telecasts this particular movie will be bound down by this sort of an order. That is what is John Doe orders. We have been giving Mareva injunction, that is the freezing injunction, prohibiting removal of assets and freezing the bank accounts of the person who violates. And we are also issuing Anton Pillar orders, that is the seizure and custody of the alleged infringing goods by the court. Now, we have the cyber laws, but we have just one act, Information Technology Act of 2000. We have not been able to bring in any act so far violation of the internet is concerned. There is no specific law has been brought in, as has been done in the United States of America, as has been done in China. They have a specific law on these subjects, but we have not been able to do that. We are using the Information Technology Act 2000, which enumerates, of course, the liability of the network or internet service provider. Now, if there is delay